So welcome to this video. We shall be looking at criminal proceedings workshop, and if you listen to the end of this video, then we shall make next week easier for you. So criminal proceedings this week involves a module that will equip students with skills required to institute post-trial proceedings. So basically we shall look at post-trial proceedings, and definitely when we talk about post-trial proceedings, then we are looking at right of appeal and right of revision. So in this module, the students will be introduced to post-trial, including perusal of records of proceedings and identification of appropriate remedies available to an aggrieved party at the conclusion of a trial in the criminal justice system. Such remedies include revision, appeals, and interlocutory remedies like bail pending appeal and extension of time for bail. Students will be exposed to the demonstrative procedures of attaining the most appropriate remedy in the circumstances of each case. The skills will be imparted to students through advisories and practical demonstration of role plays. Workshop 1, develop the ability to peruse a record of proceedings and identify errors material to the merits of the case or involving a miscarriage of justice. So basically we shall be looking at the record of proceedings. When we talk about the record of proceeding, we mean the whole trial process, because what happens in criminal law is that all trial process is always recorded, from the process of when the accused person is arraigned to court, to the process of pre-taking, to submissions, to cross-examinations, to final submissions, up to the judgment, sentencing. All those processes are recorded. So we shall be given a record of appeal, basically to identify any errors which could have led to a miscarriage of justice. So develop the ability to draft the necessary documents for a revisionary order, develop ability to demonstrate an application for bail pending revision, and develop ability to illustrate the preparation and presentation of facts on revision, and develop ability to draft the necessary documents for revision. So basically here we are looking at revision. As far as workshop 1 is concerned, we shall be looking at revision. So learning outcomes, by the end of the first workshop, students should be able to apply for revisions of matters arising from magistrates' courts, demonstrate an application for bail pending revision, illustrate the preparation and presentation of facts on revision, draft the necessary documents for a revision order. So we have a court file, and the Chief Magistrate's Court of Kampala, Uganda Road, Uganda versus Kuriaka Masias proceedings. We can see that used in court, Abdul Singh for the state, Mbire Florence court clerk, state matter for pre-taking. We can see what language do you understand. So we see that there was pre-taking. Accused, I'm applying for bail. I have sexualities, first sexuality, accused in court. Then from there we look at plea of guilty entered, count 2. So the accused took plea. Then prostitution, the brief facts are that the accused was living with one Pinti Mardad, with whom he has 2 children, in the home Borobi, where they erected a grass-thatched shed in part of their residence, which was being operated as a restaurant at the daytime and bar in the evening. That it was on the 15th day of February 2025 around 7:30 p.m. when the accused returned from the business in Chukubo and found Pinti Mardad seated and chatting with the male client who had come to pass time at the bar. The accused became so enraged and picked up a quarrel with Pinti, accusing her of cheating on him with clients in the bar. The efforts by Pinti to explain were futile, thereby forcing Pinti to leave the bar and move to their residence. The accused followed her to the house and picked a stick and hit the television screen, which was hanged on the wall. It cracked and dropped down. He started randomly destroying items such as dining table and chairs in living rooms, despite pleas from Pinti Maldad for him to calm down. He then picked a lighter and dashed out and set the grass-thatched structure in fire. As he continued screaming profanities at his wife, the clients at the bar put out the fire and apprehended the accused, but he escaped. The matter was reported to police. So we can see alloctus. So from here we can see the alloctus. Then from the alloctus we have the charge sheet as on contrary section 304 of the Penal Code Act, supported by we have a charge sheet of malicious damaged property contrary to section 312 as on section 304 of the Penal Code Act, statement of the offense, among others. So workshop tasks. But from this file, we see from pre-taking, because the accused took pre. I understand English charges read and explained to the accused person. Then he presented surety. We object to bail application. Accused is most likely to jump bail if granted. Accused raises hand in court and requests an opportunity to settle out of court. Having listened to both parties, I find the surety substantial, and accordingly grant bail. Accused is required to deposit the cash sum of Uganda shillings 1.5. The matter is adjourned. Then on force, they come back accused in court. Nyabunji Devil for the state, Mara Florence court clerk. My challenge in personal conduct is indisposed. I have received the file. I pray for an adjournment. My colleague, court, the matter is adjourned for hearing. State should come prepared to proceed. 11 sad, accused in court. Prostitution, your worship, the parties have failed to amicably reach an agreement. We have 4 witnesses present. However, we have an amended charge sheet. Court amended charge, count 1 and count 2 respectively. Read the accused in English. Accused, I request to have my lawyer present. Accused, court is true, your worship. Prostitution interjects, your worship. There is a question of jurisdiction. Your worship, Mugambe. I represent the accused. I also request to join issue with the state. Then prostitution, the brief facts. So from the brief facts we see alloctus. Because we don't see cross-examinations, we don't see submissions for no case to answer. So almost now we come to alloctus. Okay, but let us proceed. Assuming that you are the Chief Magistrate of Uganda, Lord Chief Magistrate Court, and your routine supervisory duties, you come across the file with the above proceedings. The Chief Magistrate read the legal memorandum of the High Court, wherein identify the substantive legal remedy that is available in the circumstances and discuss the merits, if any. Discuss the respondents and submitted ground for opposing the remedy envisaged in one above. Assuming that the application was formally brought forward by you as newly retained counsel for the convict by overall plea, argue the application. So basically from here we can see there is revision, and revision is a judicial process where the High Court examines and corrects the mistakes of the lower court which appear on the face of record. So you can see that from the proceedings, the criminal procedure process was not properly followed, as you don't see any cross-examinations, I don't see any leading evidence, I don't see submissions. So they jumped the process and arrived to alloctus. That means the process was not properly followed. Revision also in the case of Musoke vs Uganda, it cannot be applied for a garnish. It cannot be applied for against an interrogatory or preliminary decision of the court. So you cannot apply for revision on an interrogatory or preliminary decision of the court. So you must apply for revision for the final judgment. So the powers of the High Court, we can see the High Court exercises general powers for supervision over magistrates' courts. So the High Court may call for and examine the record of any such criminal proceedings before any magistrates' courts. Basically here the appropriate remedy is revision. Then to discuss respondents anticipated grounds for opposing the remedy. available in 1B above. So as Chief Magistrate write a legal memorandum on the High Court wherein you identify the substantive legal remedy that is available in the circumstances and discuss the merits, if any, discuss the respondents and stated grounds for opposing the remedy envisaged in 1B above. And would your course of action as counsel for the accused be the same if the magistrate had entered a plea of not guilty and had been fully tried by Chief Magistrate on 25th August 2025, convicted and sentenced him to 10 years imprisonment in count 1 and 15 years imprisonment on count 2, discuss the appropriate remedy and the possible grounds or merits thereof, assuming that upon receiving the file, your senior colleague in the law firm notes that part of the record of proceedings is missing, take the necessary steps to ensure the record is available and draft the necessary documents envisaged in task 3 above. So basically here we shall look at a revision and then applying for what? For bail. Applying for bail pending revision. Discuss respondents and specific grounds for opposing the remedy envisaged in 1 above. We shall look at grounds to oppose one application for bail, because now remember, once you have gone for revision, then the remedy would be bail pending revision. Discuss respondents and specific grounds for opposing the remedy envisaged in 1 above. So we shall see the grounds why they should do what they should. The prosecution should object to the application for bail, assuming that the application was formally brought forward by you as the newly retained counsel for the accused by overall prayer due the application for bail. Would due course of action as counsel for the accused be the same if the accused entered the plea of not guilty? Draft the necessary documents. We shall be looking at the notes of motion and affidavit in support, basically for application for bail pending revision. So basically that's what we shall be looking at as far as workshop 1 is concerned. Then workshop 2, develop the ability to peruse a record of proceedings and judgment, develop the ability to identify information grounds of appeal, develop the ability to draft documents for an appeal, develop the ability to institute an appeal, and draft the ability to prepare, present, and prosecute an appeals. So basically, whereas workshop 1 is about revisions and bail pending revision, workshop 2 is about appeals. So we have the notice of appeal, we have an indictment, murder control section 188 and 189 of the Penal Code Act. Then we have summary of the case, and we also have a charge sheet and court proceedings, agreed facts, cause of death, second agreed fact. Then we can see PW3, PW4, work week, James 49 years, re-examination, PW5, Monashi Moses, PW6, Wafra Hussein, cross-examination by Nandudu. So basically here they gave us all the process of the recordings, basically what transpired on the record, summing up notes for assessors, up to the judgment. We also have the judgment. Achingo Rebecca was found dead in the house on 12th August 2020. Now accused was arrested for murder. He denied the charge, hence this trial. So you can see we have the judgment here in. By the judgment, the defense version can only be a lie and a falsehood. The prosecution has proved the case against the accused beyond reason of doubt. I find him of murder and convict him accordingly. So what I can see from this judgment, he didn't inform him his or her right of appeal. So here we have, assuming that you are an advocate in private practice who has just been instructed on a state brief, peruse the file below and address the following tasks. A. Identify and discuss the substantive remedy available to your client. identify the preliminary steps that you will take in order to validate the substantive remedy discussed in 1A above. As counsel for the convict, assume that your substantive remedy in B above has been validated by court, draft a document that sets out the grounds that will enable you to achieve the remedy mentioned A above. By way of written submission, the other grounds that you have outlined in C above that constitute your client's case, and assume that the position of the Chief State Attorney in office of the DPP, and by way of written submissions oppose the remedy and grounds in D above, and role play. So basically here, as far as our workshop is concerned, we shall be looking at appeals. Because as you can see from here, we shall be looking at appeals. So one thing you have to understand is an appeal is a creature of statute, and an appeal is a system that enables higher courts to correct mistakes of lower courts which have caused a miscarriage of justice. So that's a right of appeal, and a right of appeal is always a creature of statute. What are the procedural steps for an appeal? You have to file a notice of appeal within 14 days. After filing a notice of appeal, later requesting for satisfied record of proceedings. Then after later requesting for a certificate record of proceedings, you have to file record of appeal, which has memorandum of appeal, record of proceedings, the judgment, and notice of appeal. So the memorandum of appeal basically has grounds of appeal. First and foremost, we shall look at the case of Famonte Henry versus Uganda, which discussed the duty of an appellant court. The first appellant court has a duty to review the evidence of the case and to reconsider the materials before the trial judge, and the appellant court must then make up its own mind, not disregarding the judgment appealed from, but carefully weighing and considering it. So basically, when you look at the case of Famonte Henry versus Uganda, it clearly tells you the duty of the first appellant court, the second appellant court, and the third appellant court. Powers of the appellant court on appeals: first and foremost, it can set aside the judgment, it can reverse the findings and sentence, it can also alter the nature of the sentence granted by the lower court. So basically, those are some of the things we shall be looking at, and but most importantly, we shall also be looking at grounds of appeal. To include one, that the land trial magistrate erred in law and fact when he convicted the appellant on insufficient circumstantial evidence. That can be one of the grounds of appeal. If the trial judge doesn't properly consider circumstantial evidence, that can be a ground of appeal. Then two, that the land trial magistrate erred in law and in fact when he failed to evaluate the evidence in totality, thereby occasioning a miscarriage of justice. So where the trial magistrate or the trial judge or the trial court doesn't properly consider all the evidence in its entirety, then it can also lead to miscarriage of justice. The land trial judge erred in law when he wrongly rejected the appellant's alibi. For example, if the alibi is not properly considered, then that can also be a ground of appeal. The trial court erred in law when he heavily relied on corroborated evidence of an accomplice. That can also be a ground of appeal. The trial court erred in law when he convicted the appellant on uncorroborated evidence of a child of 10 years. The trial court erred in law and in fact in assessment of the evidence on record and interpretation on the law of recording, the law of identification. The trial judge erred in law and fact in relying on evidence of a dying declaration without corroboration. The trial judge erred in law and fact in relying on a confession that was involuntarily taken. The trial judge erred in law and fact when he did not inform the accused person of his right of appeal. So those can be some of the grounds of appeal we shall be looking at. So basically, you have to look at the record and see which one of those ones can be found. Grounds for opposing the appeal: trial magistrate properly evaluated the evidence, it's a frivolous appeal, no miscarriage of justice caused. I shall look at bail pending appeal as an interim remedy. which is also by notice of motion supported by affidavit in support, bail pending appeal. So the documents which are draft for appeal, we always have a notice of appeal together with a memorandum of appeal, and this memorandum of appeal basically contains the grounds of appeal. So the memorandum of appeal basically contains the grounds of appeal. So basically that's what we shall be looking at workshop 2. Workshop 1 we have revision, bail pending revision. Workshop 2 we have appeal and bail pending appeal. So that's what we shall be looking at as far as this week is concerned. So basically I think that is it for this week. It's a very simple week as far as criminal law is concerned. We wish you success in your IA. But in case you want a discussion group, we have a very serious discussion group that covers all campuses, and students pay monthly subscription fee and they get notes, and they also discuss past papers. So in case you are interested, please you can reach us on the number on this YouTube, and then you can be part of the group. Please, we wish you success in your IA.